I'd like to call to order our recessed hearing from yesterday and continue with our panel of witnesses. And we appreciate very much this second panel joining us as we continue our discussion on our discussion draft relating to energy. And we have a great panel of witnesses today. I'm going to call on each one of you for 5 minutes to discuss the draft and your perceptions and thoughts about it. Then we'll open it up for questions. And I'm just going to introduce you as I recognize you for your 5-minute opening statement. So our first witness is Ms. Sue Kelly, who's the President and CEO of American Public Power Association. Ms. Kelly, thanks for being with us, and you're recognized for 5 minutes, and I would just ask all of you just make sure the microphone is turned on. And of course, when the red light goes on, that means your time is up. But so, Ms. Kelly, you're recognized for 5 minutes.
Good morning, Chairman Whitfield, Ranking Member Rush, although you are not here yet, and other members of the subcommittee. Thank you for inviting me to testify. APPA commends your hard work putting together the first comprehensive energy package since 2005. We stand ready to work with you to improve Americans' access to affordable, reliable, and environmentally responsible electric power. Today I'm going to discuss APPA's views on Title IV, Subtitle B of your discussion draft. I'll address the subtitle sections in the order they appear. APPA certainly supports increased compliance by regulated entities subject to FERC's regulations, but APPA is not convinced that proposed Section 4211 is the best way to do this. It might make more sense for FERC to review its current procedures and policies and revamp them as needed to make sure that regulated entities get meaningful and timely guidance. I do note that it would be easier for market participants to comply with FERC-approved tariffs if the applicable market rules were simpler and clearer, and I'll speak to that issue later. Moving to Section 4212, APPA believes that unless there are compelling reasons for Congress to step in, FERC should set the procedures for its own investigations. The public has to rely on the Commission's enforcement staff to protect its interests as electric consumers in these investigations. This is because third parties have no right to participate in these cases at all. If Congress does subject or give the subjects of FERC investigations additional protections, Congress must make sure that these new protections do not adversely impact enforcement staff's ability to protect the public from market manipulation. Turning to proposed Section 4221, APPA very much appreciates the interest the subcommittee has shown in the problems with wholesale electricity markets. In my written testimonies, I provide detailed comments on the provisions of that section. Some of them would be helpful in our view, but others would not. APPA has been concerned over the past 10 years about the restructured wholesale electric markets that regional transmission organizations and independent system operators, which we call RTOs, operate. Public power utilities must deal with RTOs and their markets because they are located inside the boundaries of their RTO's footprints. They are often geographically and electrically embedded in the transmission systems of larger investor-owned utilities that decided to participate in that RTO. So while our participation in these RTOs and their markets may in theory be voluntary, in fact they're not because of the interconnected nature of the grid. These APPA members deal with the day-to-day complexity and costs of operating in these markets. They must participate as best they can in time-consuming and resource-intensive RTO stakeholder processes. These processes in most regions are heavily skewed towards the interest of large transmission and generator asset owners. And the governance processes of some of the RTOs is less than transparent. So many public power utilities' only choice is to work with Congress and with FERC to seek needed reforms. Many of the wholesale electric markets that FERC has authorized are not, in fact, markets as you or I would normally think of that term. They're highly complex administrative constructs with a maze of complicated rules. APPA's concerns about RTO-operated markets include extensive and frequent rule changes, volatile pricing, which can sometimes rise to very high levels with very little warning, and limited data transparency. The most troublesome RTO markets are the mandatory capacity markets that 3 Eastern RTOs, ISO New England, PJM, and the New York ISO operate. These administrative constructs account for a substantial share of total electric bills that consumers and businesses in those regions have to pay, but they haven't shown that they can support a reliable and diverse supply of power or incent the building of new generation resources where they are most needed. consumers have paid billions of dollars in charges for these markets but don't see corresponding benefits. APPA has recommended that FERC phase out these eastern capacity markets over time. They should be replaced with voluntary residual capacity markets that better support state and local resource decisions and policies. But short of that, APPA proposes the following steps. First, RTOs that have not yet implemented a mandatory capacity market should not do so without the unanimous support of all the states in that region. And second, RTOs that already have a mandatory capacity market should not keep utilities and states from meeting their own capacity obligations through resources that they build, own, control, or contract for. Finally, APPA supports the goals of Section 4231 dealing with purpose mandatory purchase obligations. But we can't support that section in its current form. As drafted, this section would preclude public power utilities from getting any relief from their obligations to purchase power from QFs under the provision. This could leave them at a competitive disadvantage compared to neighboring utilities that do qualify for that relief. So again, thank you for the opportunity to appear today, and I'm happy to answer any questions. Thank you.
Thank you, Ms. Kelly. And our next witness is John Shel, who's the president and CEO of the Electric Power Supply Association. Mr. Shel, thanks for being with us, and you're recognized for 5 minutes.
Well, thank you, Mr. Chairman, Ranking Member Rush, and the other members of the subcommittee. I appreciate the invitation to participate in the hearing today. EPSA is the National Trade Association for Leading Competitive Wholesale Suppliers. EPSA members together have over 200,000 megawatts, fuel-diverse megawatts, essential to reliability. Over 95% of these assets are in the independent system operator and regional transmission organization territories that are the subject of the discussion draft. Reliability in these and other markets requires generation from a network of power plants operating simultaneously with baseload, mid-merit, and peaking capabilities, deploying a range of fuels and technologies because electricity demand fluctuates during the day and seasonally. As you all know, and as your hearings have demonstrated, the electric sector is in the early stages of what will likely be a multi-year, even multi-decade series of profound changes fundamentally altering the way electricity is generated and consumed. Well-designed and properly regulated competitive wholesale markets, in our views, remain the best model to manage these many changes because markets, properly regulated, are inherently more flexible, adaptable, and place more risks on investors than consumers. EPSA appreciates the inclusion in the discussion draft of energy price formation principles in Section 4421 of the draft for required wholesale power market improvements. Importantly, it's important to point out that EPSA is joined in urging FERC to act on this issue by the Edison Electric Institute, the Nuclear Energy Institute, the Natural Gas Supply Association, and America's Natural Gas Alliance in a joint letter to the Commission back on March the 9th of this year. Energy price formation refers to how these ISOs and RTOs determine the granular locational marginal prices for electric energy sold in their markets. For most power plants, energy sales are the primary source of revenue. As Sue indicated, LMP's associated revenues and other aspects of these markets are tightly bounded by FERC-approved market designs, tariff rules, and grid operator actions. Absent accurate prices in these markets, energy markets will send distorted information about when, where, and how to invest efficiently to meet future electricity infrastructure needs. There are unique characteristics of electricity that make it a challenge to arrive at prices truly reflective of total costs of providing reliable service, and we can discuss those later if you wish. Importantly for this issue, the grid operators, independent of generators, ultimately determine the dispatch of specific power plants in their regions. This generally works well to produce competitive pricing outcomes as documented through regular quarterly and annual data-driven state-of-the-market assessments from the independent market monitors in each of these regions. However, when the grid operator takes out-of-market actions, the effect is to call on plants out of merit order, and others have to stand by in reserve or do not run at all, even if they would otherwise be operated on a purely least cost basis. These out-of-market plants, when they're called in that manner, are paid what is called uplift, not the market price. Uplift, like an elevated body temperature, can be a sign of potentially unhealthy conditions, which is why the provisions of the discussion draft are so important. To its credit, the Federal Energy Regulatory Commission has been working on these issues since 2013, including 3 day-long technical conferences preceded by 4 detailed staff reports from September through December of 2014. Earlier this year, FERC posed a series of thoughtful questions for public comment on which numerous submissions from a variety of points of view have been received, and we think that docket now stands as compelling evidence that action needs to occur. While we assume that FERC is presently considering its options for next steps, we and the others in our group cannot overstate the importance of public FERC follow-up in the next several months. Decisions as to whether to retire, replace, or repower large amounts of existing megawatts throughout each of the RTOs will be made this year, impacting reliability for decades. Competitive suppliers have proven that they will respond with timely investments in these markets without preferential state-mandated contracts when accurate price signals show the need, and the results from recent capacity auctions demonstrate that that's the case. So we commend you for including this provision in the draft. We think it's important to draw attention to the issue. We think, frankly, FERC hopefully will act prior to the enactment of legislation because, again, decisions are being made now, investment signals are distorted, and the ISO RTO Council, which is the group of all of them, just last week put out a report based on a third-party assessment of investor sentiment, and this issue of out-of-market actions that the subcommittee draft would address is one of the impediments to investment noted in that report. So we appreciate the inclusion of the language that you've put in the draft. Thank you.
Thank you, Mr. Shel. Our next witness is Mr. Peter Kelly, who's Senior Vice President, External Affairs for the Competitive Power Ventures Incorporated. Thanks for joining us, and you're recognized for 5 minutes.
Mr. Chairman, members of the committee, thank you for the time and the opportunity to address these, what are very critical issues to us and to ratepayers. We are developers of power plants. We develop natural gas-fired and wind generation all across North America. We, in that process of development, identify a need, expend tens of millions of dollars in development, and then seek to commercialize those projects. This is over the course of 2 to 3 years. In some cases, projects have taken as long as 11 years to fully permit and go to commercialization. When we get to the point of commercialization, there are 2 paths, either merchant in the market, where depending on the market you're working in, you have either a 1-month to 6-month or a 3-year price commitment, 1-year guarantee that you know your price for 1 year. Makes it at times extraordinarily difficult to finance a project efficiently. Under a contracting model, you have a commitment of 10, 15, or as many as 20 years. That commitment allows you to finance a project at anywhere from 22 to 30% lower cost of capital, all inuring to the benefit ultimately of ratepayers. There have been recent challenges to state contracting and on 3 plants in the Mid-Atlantic. We expect continued activity in this litigation throughout New England as New England moves on in complying with the Clean Power Plan. There has been raised concern that these projects that are under contract cause, you could be referred to as market manipulation and impacting the market rates for all of the other generators. There are protections in place that are crystal clear in all of these eastern markets. There is mitigation or our minimum offer price rule, where if the project is determined to be economic or not economic. If it is not economic, you do not pass the mitigation, you cannot enter the market. If you do clear mitigation, you are economic. You are determined to be needed by the market. And your contract at that point is valid. And that was the theory we were operating under. As we move on with development across North America, there is an enormous need for new infrastructure. We have an aging fleet of generation. We have a clean power plan that is going to make significant changes. And we have an abundant supply of natural gas that has had a fundamental change in the energy markets. We're looking at states such as Ohio and Illinois and Connecticut and New York that are all seeking to retain generation, such as nuclear power in one instance, some coal, and natural gas and renewables. Whether they have the ability to do that or not will be dictated by the authority and what we see as a change in the authority, moving states' current authority to FERC and to the RTOs to take on and undertake what is ultimately the historical province of the states. The criteria in some cases, as they are listed under 4221B, many of those are within the province of what the states have traditionally done. And I'm not convinced that the transfer of that authority will serve ultimately the goals.
All right, thank you, Mr. Kelly, very much. And our next witness is Mr. Christopher Cook, who's President and General Counsel, Solar Grid Storage Company. Thanks for being with us, Mr. Cook, and you're recognized for 5 minutes.
Thank you, Mr. Chairman, Ranking Member Rush, fellow members of the committee. Thank you for the opportunity for us to testify here before the committee today on the discussion draft. I'm president and also co-founder of Solar Grid Storage. It's a new company, quite small in the energy business. We provide a financed battery storage solution to commercial solar and wind installations, and we developed a product we call the Power Factor, which provides backup power to those customers with a co-located solar or wind system at their site during grid outages. In addition, and key to our business proposition, was FERC's issuance of Order 755, which opened ancillary services markets to new and fast-responding technologies like ours. Solar project developers are our key customers. We're focused on providing a finance battery solution to this market segment, as it is the fastest growing market segment in the energy business. As I referenced in my written testimony, not only is the industry growing rapidly, solar costs are declining, so pardon the pun, it has a very bright future. We currently operate 4 systems in the PJM ISO, totaling 1.1 megawatts, so we are a very small company. But we are innovators in the energy space, a space where it's very difficult to innovate. I'd like to focus my comments on the discussion draft, Section 4221, particularly Section B, and 4231. We see for our business many valuable provisions in subsection B. First, though, I would point out that the title of the section discusses properly evaluating generating assets. As a storage asset, we're not either generation, we're also load, and it's difficult often for the utility industry and the ISOs to classify us. They try to put us in one category or the other. Storage is not generation. We can only take into our storage facilities in equivalent amounts of kilowatt hours what we put out. If we're storing solar energy, all we do is delay in time when that solar energy goes to the grid or to the customer. Excuse me, in subpart B, the operational characteristics of generation of electric energy during emergency and severe weather conditions, that's principally one of the things that we offer to our customers. For typical commercial customers who install a solar system, when the grid goes down, that solar system no longer functions. When they add storage to that solar installation, that installation can function throughout the grid outage in combination with the on-site solar. It's very valuable. We're seeing very strong interest in the areas of the country where they've suffered natural and other disasters that have taken down the power grid. One of the key sections in subsection 4 directs FERC to promote advanced grid technologies. We are certainly one of the most advanced grid technologies. We dispatch our systems into the PJM ISO every 2 seconds. We monitor our systems on a continuous basis. We're an incredible fast responding technology based on traditional grid resources. In section 5, and this is one of the keys for us, having FERC address regulatory barriers to entry. As a small company, and I would reflect the testimony of my co-panelists from APPA, it's very difficult for us to participate in these work groups and the other kinds of arcane procedures that both FERC and the ISOs have implemented. We simply do not have the staff or the resources to adequately participate. So that goes on as a continuous regulatory barrier to entry of our technologies. Turning to section 4231, the changes to PURPA. We would not support those changes. We feel that FERC had the appropriate balance in its Order 688 distinguishing between large generation systems above 20 megawatts that had open access to the grid and those below 20 megawatts that on a rebuttable basis did not have non-discriminatory access to the grid. We feel that FERC struck the proper balance there, allowing a rebuttable presumption such that if there was an open access transmission tower for those small generators, the entity that was suggesting that those small generators did not have open access could go to FERC and rebut that presumption. They have the resources, they have fast, superior resources in the small generators in almost all cases, and are able to support that. In addition, the breakpoint of 20 megawatts is a good one. Typically, above 20 megawatts, those systems are all interconnecting at the transmission grid, much more expensive projects, much more complex projects. Below 20 megawatts includes, under some of the FERC orders, systems down to the residential size. And can you imagine a residential customer who's installing solar on their house and perhaps a battery with the potential opportunity to earn revenues from those systems in those grid markets, having to present their case at FERC that they're entitled to those PURPA qualifications? Thank you.
Thank you, Mr. Cook. Our next witness is Mr. Jonathan Weisgal, who's the Vice President, Legislative and Regulatory Affairs for Berkshire Hathaway Energy.
Thank you, Mr.
Thanks
Chairman.
very much for being with us. You recognize 5 minutes.
Appreciate it. Thank you, members of the subcommittee. Berkshire Hathaway Energy, we own 3 regulated utilities that serve 5.3 million customers in 11 states. Like Mr. Cook and Ms. Kelly, I also want to address Section 4231 of your discussion draft on PURPA, the Public Utility Regulatory Policies Act of 1978. PURPA mandates utilities to buy renewable energy from QFs, qualifying facilities. That law today is imposing significant and unnecessary costs on utility customers. For example, it requires a utility to buy electricity from a QF regardless of whether the utility needs that power. PURPA contracts are not subject to the same resource planning and cost scrutiny as other utility decisions, and they can cause operating inefficiencies and reliability issues because the host utility has no control over where they are sited or integrated into its system. Let me give you a specific example. The long-range plan for our PacifiCorp utility, approved by our state regulators, shows no need for additional generation until 2028. However, over the next 10 years, PacifiCorp must purchase 39 million megawatt hours under its PURPA obligations at an average price of $66 per megawatt hour, although the average market price today is $38, 43% lower. That means that our customers must pay $1.1 billion above market prices for PURPA-mandated power that they don't even need. And this is not an isolated example. Many other utilities are facing similar dilemmas. Now, Congress amended PURPA in 2005 to relieve a utility of its mandatory purchase obligation if it can show that the QF can compete to sell its power. In other words, has access to a competitive market run by an RTO or an ISO. That's actually why many of you have not been hearing about this issue from your constituents, because your local utilities belong to one of these competitive markets, PJM, ISO New England, New York ISO, MISO, and the like. But PURPA and FERC's overly restrictive implementing regulations have not kept pace with market changes in our industry. Today, new energy imbalance markets, competitive resource solicitations, and FERC's interconnection rules for smaller facilities have effectively removed any remaining barriers for new entrants, including QFs, to supply energy to markets where the host utility is in an organized market or not. PURPA needs to be modernized to recognize these changes. My written testimony details the technical suggestions that we and the Edison Electric Institute have for modernizing PURPA. The first is to expand the definition of comparable markets that are eligible for termination of the mandatory purchase obligation to include voluntary, auction-based energy imbalance markets and other sub-hourly markets. The second is to eliminate the presumption in FERC Order 688 that QFs under 20 megawatts lack non-discriminatory access to markets, provided that the QF is eligible for service under FERC-approved tariffs and interconnection rules and can participate in utility competitive solicitations. The third is to terminate the mandatory purchase obligation upon a state regulatory agency determination if certain conditions are met. And the fourth is to prevent larger QF projects from being divided into smaller ones to essentially game the so-called FERC 1 mile rule. Now, some say PURPA should be repealed outright. We don't believe that's the right approach. Our proposals are not about removing the mandatory purchase obligation where competition does not exist. Not all utilities operate in states where there is an organized market. Not all state regulators require competitive bidding when a utility is looking to secure new or replacement power. In those states, PURPA still serves a useful purpose, and our proposals would not change that. Others have asked that if PURPA was passed to promote renewable energy, aren't these suggestions designed to inhibit renewable energy? My answer is an unqualified no. After 37 years since PURPA was passed, renewable energy is flourishing, and our company is among its strongest proponents. Indeed, not including our original geothermal assets, we have invested nearly $18 billion in the last decade alone in wind and solar projects in 10 different states. But these projects have been driven by policies other than PURPA. They've been driven by state renewable portfolio standard mandates, federal tax incentives, technological improvements, and stricter EPA air regulations. Are these changes designed to inhibit expensive and gamed renewable energy? Yes. But regardless of your views on renewable energy, everyone should be in favor of fair market rules as well as getting customers low-cost electricity, not high-cost electricity, caused by what is now outdated legislation. Thank you for the opportunity to share our views. Look forward to any questions you may have.
Thank you very much. And our next witness is Mr. William Sherman, who is a partner at Gibson, Dunn & Crutcher. Thanks for being with us, and you're recognized for 5 minutes.
Thank you, Mr. Chairman and Ranking Member Rush. I appreciate being here. I have to say at the outset, these are my own views and not the views of any of my clients. Let me start by saying there must be meaningful and structural due process reform of the FERC enforcement process. Both substantively and procedurally today, entities subject to the FERC enforcement process do not receive due process of law. It is not only important that they receive due process of law, but without it, the very competitive markets that this committee is trying to promote in other sections of the bill will be harmed as people and market participants continue to flee from the markets and liquidity is decreased and price discovery becomes non-existent. It is simple fairness to require FERC to give people exculpatory or potentially exculpatory information. It's simple fairness to allow access to transcripts. It's simple fairness to allow subjects of investigation comparable access to the adjudicator, the FERC commissioners who decide their case. What you heard yesterday was none of these reforms are needed because at the end of the day, many participants have the right to go to federal court to seek review of FERC enforcement matters. If only that were true. What occurs today is that in those instances where you have to go through a FERC administrative process, the federal rules of evidence do not apply, the federal rules of civil procedure do not apply, and when the case gets to the Court of Appeals, the record that the FERC has developed under flawed procedures is given deference. And even when you can get to federal district court under de novo review, the FERC today, in 2 pending cases, is doing everything possible to restrict having the ability to have a full trial in federal court with the full rights of discovery and the full rights to have meaningful opportunity to test FERC's cases. That is the process the FERC is trying to tell you is not occurring today and why we badly need procedural reforms. I also strongly support the section of the bill that would require FERC to address the existing RTO and ISO markets. There is strong evidence to suggest that the existing ISO and RTO markets are no longer producing competitive results. There is strong evidence to suggest that they are no longer balancing supply and demand. It has not been since the Federal Power Act was first enacted and the just and reasonable standard was adopted that the Congress has helped to define what constitutes just and reasonable markets, even though these markets have become, as Ms. Kelly said, incredibly complicated and very much complicated to participate in. It's time the Congress help define what constitutes just and reasonable markets in this current market environment. What you heard yesterday in response to a question from Mr. Shimkus was that the FERC is working on these matters. Mr. Shel talked about that this morning. The FERC has been working hard on these matters, but without the Congress spurring the FERC to act, either through legislation or through a letter from the committee asking them to act by a date certain, many of us are concerned that the FERC is hopelessly deadlocked and cannot achieve a consensus on these important initiatives. that section of the bill might very well spur action, and I support it completely. I agree with the PURPA reforms that have been put in the bill. I won't spend a lot of time on that, but I want to talk about 3 parts of the investigation process in a little bit more detail in the few minutes I have left. Yesterday, you heard that there's a difference between the adjudicative phase and the investigatory phase of FERC investigations. That is an illusion. It does not exist. How do we know that? Because in April of 2013, the FERC ruled that a show cause order is not part of an adjudication. It's part of the investigatory process. That is a FERC order. The reason why FERC wants to give you this illusion that there's an adjudication at FERC is because they understand and have admitted in the law review article that was cited in their testimony that in the investigation stage at FERC, witnesses and subjects of investigations do not receive due process. That is in that law review article that they cited to you yesterday. So in order to get around this admission, they have to try to convince the Congress that there's a real adjudication phase at FERC. There isn't. It is not an adjudication phase when a witness gets, a subject gets, no rights of discovery, gets no ability to test the other side's case, gets no access to the decision maker. That is not an adjudicatory process. You heard yesterday that the Brady reforms in the bill are not necessary and they be unparalleled. That's shocking. The language in the bill comes straight out of district court cases on Brady. And if in fact that, and in fact those cases have been cited to the commission in a number of key cases. That is absolutely not true, but it is a simple fix. Take out the word helpful that Mr. Parkinson objected to yesterday and put the word favorable in 2 places. Delete the word favorable, delete the word helpful, put the word favorable in. There is no possible way at that point that they can object to that. Finally, the staff has now admitted, the FERC enforcement staff has now admitted to this committee that they have violated their own regulations and the Administrative Procedures Act at least 12 times in denying access of a witness to their transcripts. That is now on the record in this committee. So if there's any doubt that these reforms are needed, I would suggest look at the record. Thank you.
Thank you very much, Mr. Sherman, and thank all of you for your time. I'll recognize myself for 5 minutes of questions, and I would like initially just focus on 4231 relating to so-called PURPA reform. Ms. Kelly, you had indicated that you felt like there should be some reform perhaps, but our language you did not particularly agree with. Would you explain more detail what you would recommend?
Well, can you all hear me?
Yeah.
The situation is this. The way the provisions that you have drafted are written, it applies to, in effect, to state-regulated utilities or FERC-regulated utilities. My members are units of state and local government, and by and large are regulated at the local level by their governing boards. So the way the language is written, and this may well have been an oversight, was just in a way that
You're left out.
qualify.
You're left out.
Yes, we are left out. Thank you.
Okay.
That's the long and the short of it.
Okay. What's that? Okay. And Mr. Weisgal, now, you'd mentioned that you're paying something like $68 a megawatt for power, and the actual cost is $30-some, and parts of your operation, I guess, was in California or in Portland or
Northwest, yeah. Mhm.
Yeah. And now, is that a result of the calculation of the avoided cost, or what is
Yes, I mean, the avoided cost calculations are made by state regulatory agencies. PURPA contracts have lengthy durations, so we are looking at contracts with fixed price costs for a long period of time. Markets fluctuate. That's why we prefer the competitive process in the market. But when you're stuck with a PURPA contract, historically, those have tended to be way above market. Now, that's not a congressional problem. That's more a result of state regulatory agencies in that avoided cost proceeding. And figuring out avoided cost is really a full employment job for lawyers and has been for many, many years under PURPA. It's been very complicated, but the tendency has been way above market costs.
So, Ms. Kelly, is avoided cost an issue from your perspective, or you? Go ahead.
It's less of an issue for us, the actual calculation that was referred to, because in the case of state-regulated utilities, they are developed by the state PUC, and they can be very administratively determined. At the local level, we have a better read on what our potential options are, so we have a little more leeway in setting avoided costs. So it's not, that part is not as big a problem for us as the fact that we may be, in effect, it's a put at a certain price, and we have to take it
Right.
whether we need the power or not.
In 1978, when PURPA was adopted, I don't think that many people thought the investor-owned utilities would also be qualifying facilities, at least initially. What percent of qualifying facilities today would you say are owned by investor-owned utilities? Do any of you have any idea on that at all?
I would think it's pretty low to almost non-existent, given the size. If I could just add, the issue, as I indicated earlier, 95% of our member assets are in the RTOs. So this is not an issue for our members, but I can say it is an issue for the independent power producers outside of the RTOs. And the reason is, notwithstanding what Mr. Weisgal said, from their perspective, and I've urged you to talk to them, if you don't at least address what it means to have a competitive solicitation, I think the bill's got the right directional idea. I was very much involved in the compromise negotiated in 2005. The issue, however, is just because a state has a competitive solicitation on the books doesn't mean it's a fair one. So you may want to think about at least expanding what type of competitive solicitation you think would qualify, because right now the utilities like Berkshire Hathaway outside the RTOs, they get to run the solicitation, they get to put their own projects up, and miraculously they pick themselves, well over 95% of the time. So I think you'd want to be clear that in the draft what type of competitive solicitation with a third-party evaluator would qualify for the exemption. Otherwise, you risk reducing competition in those regions.
And would one of you make just some brief comments on the transparency issue at the RTOs relating to price? I think you and Ms. Kelly had indicated that was an issue from your perspective.
Yes, that is an issue, and thank you for the question. I think one of the things that strikes us with some regularity is the volatility in the prices. For example, in capacity auctions, prices can vary very substantially from auction to auction, both up and down. It's unclear why that happens. The data that goes into those prices is closely held. We have talked about increased transparency of bids and offers in the past. A lot of other people have opposed that, so that has not yet happened. It was considered in a stakeholder process back in 2008, 2009 at our request, but shockingly, by the time you got done with the stakeholder process, the consensus was that that wasn't required. So there have been issues with that in the past.
And I would, at some point, like to discuss in more detail the phasing out of capacity markets in the East. I think you made reference to that as well.
I would be happy to do that. I would note that that's a longer-run prescription. These markets are very complex, and they do operate on a 3-year forward basis.
Yeah.
So we're not saying that that's something that, can be done in a flash cut. We understand it's an important, complicated
Mr.
issue.
Sherman, do you want to make a comment?
I do think it's important for the committee to understand that when a competitive solicitation is run by a utility, if that utility would like an affiliate to participate, the FERC has very stringent rules called the Edgar-Allegheny rules. I won't bore the committee with the details.
The Edgar-Allegheny rules?
They're based on 2 cases. Everything has to have a name, Mr. Chairman.
Yeah.
It's an Edgar case, an Allegheny case, and so it's become known as the Edgar-Allegheny rules.
Right.
They're very prescriptive as to how the evaluation has to be done by an independent evaluator, what has to go into competitive solicitation, and how that record has to be developed before a utility can pick an affiliate. Those rules are very robust, so it's not as easy as the utility just picks its affiliate.
Yeah.
And therefore, Berkshire Hathaway Energy sometimes loses.
Okay.
But
I want
those
to
only
just
apply in the FERC context. They don't apply at the state level when the decisions are made to select which projects. So
Yeah.
I'm sort of comparing apples and oranges here.
do you know if Exelon in the Exelon Nelson case in Texas appealed that Fifth Circuit Court of Appeals ruling?
I do, and I believe they were not successful.
Okay, thanks. This time I recognize the gentleman from Illinois, Mr. Rush, 5 minutes.
Thank you, Mr. Chairman. Mr. Kelly, in your written testimony, you argue that Section 4221 as currently drafted may result in an unintended consequence of pitting FERC and the RTOs into an unnecessary and potentially divisive debate and result in states having to rely increasingly on the volatile short-term markets. My question to you is, what recommendations, if you have any, that you would suggest to this committee for the improving the language in section 4221? Or do you believe this entire section is of no use and may even be counterproductive?
No, there's certain parts of the section that I think add value, but I think we look at the traditional function and role of the states and their public service commissions and legislatures, and determining, such as I believe it's 2A, operational characteristics, the generation of electric energy on a continuous basis. That's a state, ultimately a state issue. Whether or not the state is going to cite, for instance, dual fuel generation for us in the natural gas generation. They request or require at times that you have oil available so that you can run for a minimum period of time. The ISOs and RTOs have rules as well, and there is some payment structures in place that ultimately force you to have that ability or penalize you if you don't.
Mr. Rush, if I could just add briefly, we don't view the section or read the section the same way Mr. Kelly does. It's not changing what is a bedrock principle of the Federal Power Act, which is that the federal government through FERC has jurisdiction over the sales of electric energy, interstate commerce, and transmission. That's not changed at all. What the section says is to the extent FERC does things, and FERC does important things, we may disagree about how they do them, but the wholesale markets that FERC administers for energy and capacity are what supply the power in Illinois and other states in the committee where the RTOs exist. And so FERC does decide the market rules. Sue and I may disagree on how they do it, but FERC's the agency that decides how wholesale markets operate. That's been upheld by the court. So I think the section, at least the way we read it, is directing the commission to consider a range of issues. Some we like, some we don't. But I think it's a pretty good balanced list directed at FERC. It would not upset the federal-state balance.
Are there any other witnesses who might want to weigh in on this?
Yes.
Ms. Kelly?
First of all, I would note that the way the section is set up, and I noted this in my written testimony, is it directs each RTO to develop in consultation with the stakeholders. So at the very get-go, you're sending it off to the stakeholder process. And that is an endless frustration loop for my members for the last 10 years, because those processes, especially in the RTOs where the market, problems are the most acute for them, the large generation and transmission asset owners hold a great amount of sway for the reasons in my testimony. So that right there is a problem. Some of the provisions of the things that they're supposed to consider, I think, are very salutary. Others, I think, are less salutary. But to me, the immediate problem is it goes off to the stakeholder process. And that's something you all probably need to look at more carefully. Thank you.
I think the simplest way to fix that problem is to make it clear that when the commission is exercising the authority in the section, that it's being done pursuant to Federal Power Act Section 206. And therefore, when the RTOs and ISOs have to respond, they have to make a filing under the Federal Power Act to comply with those specific criteria. And at that point, there will be no doubt that it's wholesale only and not of trying to affect the retail market. The second point is absolutely what Ms. Kelly is absolutely true. The current stakeholder and governance process of the RTOs is so cumbersome and so complex that it leads to least cost, least common denominator decision-making that's frustrating innovation and stifling competition. The Congress really does need to address that if the FERC can't.
Mr. Cook?
Thank you. I think the concept behind Section 4221 is good, particularly the things that direct FERC and the ISOs to look at advanced grid technologies and to look at the kinds of regulatory barriers that exist to incorporating those technologies into the grid. Our technology is a customer-sited technology, and it really makes some of the ISO leaders' heads spin that a customer-sited technology could provide transmission grid services, but in fact, we do that. We dispatch our systems as a virtual power plant. I would agree, however, with my fellow panelist, Ms. Kelly, that the stakeholder process is extremely cumbersome for small companies like ours. Being able to dedicate the kinds of resources that are necessary to them for day-long meetings that occur every other week, that could go on for six to 18 months, is virtually impossible. So our voice does not share the same weight as the voice of the traditional transmission owners, the big utilities that are involved in those processes.
One thing, Mr. Cook, I have a few more minutes, and in your testimony, you state that you believe that FERC struck a proper balance in Order 688 with its presumption that larger generators had open access to transmission markets, but also a rebuttable presumption that smaller systems do not. What changes do you think are necessary in the discussion draft in order to maintain the balance of FERC Order 688 and to maintain the rebuttal presumptions regarding access to open transmission markets?
Well, the simple response would be no changes are necessary. I believe that is the proper balance. The new language in Section 4231 would change that presumption and says specifically that generators of any size are presumed to have open access. I don't believe that's factually correct. The small generators typically have barriers. If you're a 100-kilowatt generator, for example, in many ISOs, you can't participate in any of their markets simply because of your size. They arbitrarily set the threshold of participation at 1 megawatt. So there are numerous different barriers that small generators face. I believe that what FERC did was to say, well, if you have access to an open access market, there's a presumption for the big generators that you don't need any of those purple protections. But there's a different presumption that on the small generator side, you do need those. It is a rebuttable presumption, so it's not guaranteed that you're going to get those protections. In addition, I think on the avoided cost question, the issue of the proper setting of avoided cost is done by the utilities and the state regulators. The small generators that avail themselves of that avoided cost typically, again, do not have the same representation in those proceedings. So if there's an error in the avoided cost calculation, I think it's incumbent upon the participants in that proceeding to properly set that so that avoided cost is truly reflective of the utilities cost and there isn't an overpayment to the small generators.
Thank you, Mr. Chairman, for your generosity.
Yeah. Well, you know, these issues are so simple and not very complicated that we don't need a lot of time to talk about them.
Might I just say one thing to your
Yes, please,
question,
by all means.
Congressman Rush? I would just note that there are also small utilities in addition to small generators. And for some of them, the 20 megawatt cutoff is a lot bigger than they are. So, and actually back in private law practice, had a rural electric co-op client who was asked in effect to purchase the output of a small generator much larger than it was, or to wheel that out when that was, bigger than its entire system. So you need to be sensitive to it on both sides.
Yeah. This time I recognize the gentleman from Virginia, Mr. Griffith, who understands all of this completely for 5 minutes.
Well, thank you, Mr. Chairman, and I'm just a simple country, small-town lawyer, but listening to Mr. Parkinson's testimony yesterday, I came away clearly from his initial testimony. He backed away from it a little bit, in fairness, but came away from it initially believing that our system does not allow due process and that it is not fair to those people who are being accused of having manipulated electric rates or et cetera. Mr. Sherman, I gathered from your testimony that I might have had the right sense.
Yes, sir, I fully agree. I have great, and let me just state, none of this is personal. Mr. Parkinson's a fine fellow. Chairman Bay is a fine fellow, but the due process people receive at FERC today is in name only. The FERC is doing everything it possible to frustrate constitutional due process requirements. And all you have to look at, Mr. Griffin, is the disproportionality between, in the current pending cases, between what the FERC is alleging as the market harm and the size of the penalties. And if I could just enter a couple of those into the record.
Please do.
In the current maximum power case, the FERC has alleged a $5 million civil penalty with zero unjust enrichment, zero disgorgement of alleged unjust profits. In the current Powhatan case, the disproportionality between the alleged disgorgement and civil penalty is 634%. In the current BP case pending before the Commission, the disproportionality between the civil penalty that's being sought and the alleged unjust enrichment is 3,500%. In the Barclays case, the disproportionality between the alleged unjust enrichment and the civil penalty is 1,300%. In the Lincoln case, the disproportionality is 1,300%. So if you just look at whether the proportionality between the alleged unjust enrichment, the alleged amount that they shouldn't have earned, and the civil penalties, it's clear there's no proportionality in the way the FERC is administering the enforcement process.
Well, and I appreciate that testimony. I was struck with just the basic principles of due process that have evolved over the years in the Anglo-American system when, you know, I heard things like, you know, we don't really want third parties to have to worry about Brady. In other words, information that might say the person or the accused didn't do what they've been accused of. Well, third parties shouldn't be burdened with that. That bothered me. And then the whopper of all, and the defense was, well, other people do it. I don't accept that from my children. I'm not going to accept it from the federal government, of which I'm a representative of the people, was, well, you can't really talk about settlement with the commissioners because they're part of the prosecution team, because we have an attorney-client privilege with them, and we don't want that to be violated in any way. Say what? There's an attorney-client privilege between the trier of fact and the investigators who bring the case? That just struck me as abhorrent to the American legal system. Do you agree or disagree, and what are your comments?
I fully agree. The Commission is applying the wrong Brady standard. It is clear from the testimony that they are applying the post-trial Brady standard, not the pre-trial Brady standard. Other regulatory agencies, including the CFTC, rejected, as part of their process, the post-trial Brady standard over 20 years ago. This is not a new concept. On the settlement process, it's the classic case of trying to negotiate for a car. You negotiate with the enforcement staff only to be told, oh, I got to go talk to my manager. Well, we know what happens every time you go talk to your manager. And in a recent case where I asked directly to negotiate with the commissioners on a settlement, and I said I would be more than happy to have the enforcement staff in the room at the time, I was told it was against policy to talk directly to the commissioners, even though I said I would be happy to have the enforcement staff in the room at the time.
Sure, and I can understand that why they might not want to have ex parte communications with the commissioners, but if they're part of the prosecution team, it does seem kind of strange. Do you think we'd be better off allowing the commissioners to continue to have the settlement power, but just move any disputes directly to the district court where you can have a legitimate due process-filled trial?
I think that would be a very good suggestion if the Commission itself would recognize the words de novo review in the statute mean a trial. What's happening in the Lincoln case and the Barclays case now is the Commission is taking the absurd position that the words de novo review does not lead to a full trial, does not lead to discovery, does not lead to the right to confront witnesses. They're taking the position that a de novo review is essentially no different than a court review, where the Commission gets deference on the record that they built in a flawed process. Yeah. So if the Congress would clarify and confirm the existing language means what it means, and it should apply to the Gas Act, the Power Act, the NGPA, that would help a lot.
Well, and even a simple small-town lawyer knows that de novo means you get a new one. That's what novo means, new, and that that was their defense yesterday in part, was that, well, you can always go to the district court. I would think that would be a big fix if you could actually get a new hearing with all of the discovery rights that you get in
Absolutely.
in the normal court
The Power
system.
Act supposedly provides for that, but apparently the Commission doesn't agree with that.
Well, I appreciate it. My time is up. I yield back. Thank you, Mr. Chairman, for this important hearing.
You know, I had about 7 minutes. Mr. Rush had 7 minutes. Do you want to take another couple of minutes, and then we'll give everybody 7 minutes, because this is a complicated issue, and we want to give everybody an opportunity. So if you want to go for another minute and a half.
Well, I will say that I was a little concerned that the commissioners are part of the prosecution team, as we've previously discussed. And do you think that that is a new development, or is that something that's been evolving over the years?
It is both. It is certainly something that is not a new development, but it has evolved over the years in a much greater sense. And part of the problem is, when I was general counsel of FERC, the enforcement process reported to the general counsel. There is a layer between the enforcement process and how that was administered on a day-to-day basis and the Commission. What you heard in Mr. Parkinson's testimony was that there's free, regular communication between the investigators, the prosecutors, and the ultimate decision makers. And that because, and just human nature would suggest that that cannot be a fair adjudication. It has nothing to do with the the integrity of the commissioners personally. But if you're told for 5 years that somebody is guilty of fraud, if you're told for 5 years that somebody's manipulated the market, if you're told for 5 years that somebody has unjustly enriched themselves at the detriment of consumers, and then all of a sudden, at the very last part, you then have to sit where only one party has had access to you, where only one party knows what you're thinking, where only one party's had a free exchange, that is a problem. May I give you an analogy?
Sure, because I agree with you completely.
May I have 1 minute to give an analogy, Mr. Chairman? You have 37 seconds. Okay. Suppose there's an FBI agent who investigates a case for a number of years. That agent's also a lawyer, as many of them are. That FBI agent then decides, I'm going to go be a lawyer, and goes clerking for a federal judge. And suppose that same lawyer, who's now a clerk, the judge that he's working for ends up being the person who hears the case that he was investigating. And he gives him advice for a couple of years about what the cases he's investigating. And then he supposes after a couple of years of clerking, he wants to go be a prosecutor. So he's assigned as a prosecutor, and lo and behold, he gets the case that he investigated, and then he advised the judge on how to decide the case. And then he's the prosecutor.
Well, I think
that's the FERC process.
And I think anytime you have an attorney-client privilege with somebody, they ought to be disqualified. It creates an appearance.
Recognize this time Mr. McNerney for 7 minutes.
7 seconds. Thank you, Mr. Chairman. Mr. Sherman, I just want to let you know I appreciate your devotion to fair play, because that's what makes America great. Where I'm coming from is a point of skittishness after being manipulated in California, having Enron taken $9 billion and leave us with a lot of problems. So what I ask is, do you feel it makes sense for us to try and persuade FERC to improve their behavior, or do you think it makes sense for us to enact new legislation to force the issue?
I would certainly prefer the latter, but if there's some way to do the former, that would be great, but there's no evidence to suggest that would work. And let me just tell you about Enron. I understand that the California energy crisis is still a hangover, if you will, over how we all think about this. What caused the California energy crisis, which harmed consumers, no doubt, was a myriad of factors. One of the most important one is what this committee is trying to do in other parts of the bill, which is to get efficient market design. One of the key problems in California was that it was an inefficient market. The market design was badly flawed. One of the key ways to prevent those kind of crises from occurring again is to make sure the RTO markets, the California ISO, is operating in an efficient way. That is an important reform that, along with the ex partes, would ensure that those kinds of problems don't happen again.
Well, I've heard this morning from Mr. Shel about the importance of properly regulated market. We heard it from Southern Company last week as well, the importance of proper regulation. So is that what you're talking about, is regulation, or are you talking about a free market where anything goes?
There's no such thing as a free market where anything goes.
Clearly.
These markets are heavily regulated. What we're trying to do is to get the market rules to simulate competitive outcomes, because many of us believe competitive outcomes are in the best solution of the consumer. But the FERC and the state commissions have to always be vigilant to make sure that the markets are properly regulated. But you can regulate in a way that's designed to produce and simulate competitive outcomes, and that's what I advocate.
So do you think that this legislation gets us in that direction? Or?
I think it's a very important step. Yes, sir, I do.
Okay, Mr. Weisgal.
Well, let me take a crack at that give you a concrete example. In Idaho, a developer came to our utility with on a competitive solicitation process with a 150 megawatt wind project. They didn't win. Next couple of years, they disaggregated the project into several below 80 megawatt projects and turned it into a PURPA project, where our utility had no choice but to buy that power at an above market price. There was a competitive process. They lost, so they used the hammer of PURPA's mandatory purchase obligation. One aspect of your discussion draft is designed to enhance that competitive process, and in that case, where there would be an open competitive process, that kind of result would not happen. Now, that's not necessarily Enron-like, but that, to go to the chairman's earlier question, is sticking our customers with higher costs because the project had originally been rejected, so it was simply disaggregated into smaller ones to make sure that it could fit into a PURPA mandate.
Well, I'm sure there's plenty of examples like that to go around. Ms. Kelly?
Thank you very much for recognizing me. I feel that since FERC is not on this panel, perhaps somebody needs to speak up for the interests of the other side. I would just note that what they're trying to do is protect consumers in these electric markets. And if you look at the orders that have come out, you look at the entities who are being chastised, you look at the behavior in which they engaged, I think a case could be made that it's really important to have a strong enforcement at the FERC because consumers are otherwise going to be taken to the cleaners. The part we worry about is how much else is going on that has not been caught, especially in these centralized markets with their very complex rules. We feel like it would frankly be more useful to get the Commission or for this Congress themselves to take a more holistic look at whether these markets are being systematically manipulated and whether these are just kind of the icebergs that show above the surface. We are quite concerned about the operation of financial players in these markets. We have been for some time. Thank you.
Well, I mean, that kind of makes the point. We need a strong regulatory arm, but it needs to be fair. So what my concern is that this Section 212 goes a little too far in neutering the FERC's investigatory ability.
I don't think it neuters it at all. I mean, it simply levels the playing field to provide constitutional due process. And it's easy to say, don't do this when your members are not subject to the very regulations that are violating due process. Ms. Kelly's members are not subject to these rules. They're not subject to this enforcement process.
Not true.
Well, it is true, Sue. Other than NERC, what is you subject to?
There actually was one enforcement proceeding against one of my members in ISO New England.
One?
Yes.
Okay. Sorry.
Generally speaking, we don't engage in behavior that would require that.
Okay. Of course not. I'm sorry.
Mr. Shel, what do you see as some of the dominant trends? You said you see profound changes. What are some of the dominant trends, and how would this legislation harm or enhance those trends?
Well, we're all confronting a number of things, regardless of business model, whether it's Ms. Kelly's members in public power, ours in merchant generation, and others at the table. Everybody's up against what's been an unhitching, if you will, of demand from economic growth, which is generally a good thing, so we don't need as much electricity as we used to. But so it's flat demand at a time when most revenues are volumetric as an issue. We obviously have a changing fuel mix, legislative requirements in California and elsewhere for renewables, all the environmental regulations, the technology. So it's safe to say, while we're sitting here in 2015, in 5 or 10 years from now, it's going to be a dramatically different electricity system. It's just hard to predict exactly how different it's going to be. If grid storage comes on in the way it might, if different technologies come about, it's going to be very, very different. So that's why we have to be careful. I think what the draft tries to do, instead of being prescriptive and writing into statute for all time, like happened in '78 and other times, things that would be hard to change later, you're giving general direction to the Commission on a range of issues. Like Ms. Kelly, some we like, some we don't. Our list might be a little bit different. But I think the intent of it is very, very good, which is to set out the goals, set out what you want to have the ultimate result be, and then let the Commission, the experts at the Commission, work through this on a bipartisan basis. So I think it would be overall helpful to deal with the change you asked about.
Thank you.
Gentleman's time has expired. This time recognize the gentleman from Illinois, Mr. Shimkus, for 7 minutes.
Thank you, Mr. Chairman. It's great to have you. This is a great hearing, and I love the back and forth and the trying to address it. But it's hard to argue against legitimate due process and equity and fairness, regardless of the players. I mean, Morgan's great to have on the committee because he's got a good legal mind, and sometimes we bash lawyers. They're good to have around when you need them, and when you got smart ones, they're great to listen to. So, and I missed his performance yesterday, so I guess I got the tail end of it in this one. I'm going to get back to a simpler aspect I talked about before the hearing to some of you. So I put up what I got. That's what I took a picture of while and we got it up there, and you can't see it, but I'm in the MISO area, So, and this happened, I found out this has happened a couple times after we've done some due diligence. And so it's the auction clearing price debate. We've just had an auction. Yeah, we have a lot of zones in the MISO region. Most of the zones cleared at $3.40. Well, there's $3.29, $3.48 in that range, except for one zone, which happens to be Illinois. That's why I know about it. And it cleared at $150, 300% increase. And in doing due diligence and visiting with FERC, this has happened before. I think it happened in the Cleveland area a couple years ago. So I have a couple questions. Obviously, I'm trying to understand this. I mean, it's a 300% increase. That gets your attention. It's got attention of my individual consumers. It's got the attention of the business interests, the manufacturers who are going to be using power. And so the first question is, MISO decided to do an annual auction versus some regions do 3 years. And I want to ask Ms. Kelly and Mr. Shel first, do you think that one model is better than the other? MISO, in essence, MISO bet that they would have better auction results by doing it yearly. And at least in my region, they really got bit this time somehow. So can you kind of understand how I laid out the question?
Yes. I think I can. It requires me to go a little bit in the weeds, though, so I apologize in advance. This particular market in MISO was what's known as a residual market. In other words, you do not have to obtain your capacity from that market as you do in the Eastern RTOs. As a result, the time horizon is shorter. It's just a year ahead.
But that's a MISO decision, though.
Yeah.
I mean, they could have gone, they could have a 3-year.
They could,
Okay.
but because most capacity is procured outside that market, it makes less sense to go out in a longer term than it would in a mandatory market as in the East. The other thing to note here is one of the reasons that that result happened is because of the size of the zone that the price was formed in. What happened was Dynegy bought a lot of assets in that region the year before, and as a result, I think they controlled over 60% of the generation in that zone. At one point, MISO had talked about lumping 2 zones together to mitigate that and make them less of a generation, what we call a pivotal supplier in that zone. That was discussed in the stakeholder process, but in the end, that did not happen. One of the complaints that I've read about this alleges that a Dynegy employee was actually vice chair of the relevant committee in the stakeholder process that made that recommendation. And this gets to the point I made in my testimony about threatening to leave because the generation in the southern part of Illinois, Dynegy has in the past made noises that they might take that over to PJM. So that's I think one of the reasons why that's what this complaint alleges. Let me just say that that's one of the reasons why that change was not made and they were left as the dominant supplier in the zone. And sure enough, the next auction, the price spiked. So, that's one of the things that gives us as consumers very strong concerns about how these market rules are set, how the zones are set, and how arbitrary and, volatile the prices can be from auction to auction.
John?
I think the question
I think you need to turn it on.
The question you asked is a good one about the market design. We've generally favored the multi-year approach in PJM and New England, and the reason is simply that you then get the forward price signal much earlier. So I think the Cleveland example you gave is a very good one. When the price went up in that what's called the ATSI zone in the Cleveland area a few years ago, then the next auction, many developers came in. In fact, you're seeing development around there not only because the price went up for that 1 year, but because of the Utica shale gas. So there's a gas basis differential, and these new gas plants can go in there. In terms of the conduct of this auction, I think it's important to point out that MISO does this rigorously in terms of overseeing the auction. There's an independent market monitor. The rules are strict about what can and can't be offered. Ms. Kelly mentioned Dynegy. They offered all the megawatts in there that they have. And as you know, what separates Illinois from the rest of MISO, from southern Illinois, is the competitive generators there are only dependent on the revenue from that auction and the energy market. The other states, as Ms. Kelly indicated, are outside of it. So if you actually look at the southern Illinois price compared to the northern Illinois price, they're about the same because that's the only source of revenue to signal new investment. And I'll imagine if we have this conversation a year from now, particularly if MISO has a longer lead time, you'll see people come on to invest in Southern Illinois as they did in Cleveland and they're doing in New England when the price went up in New England.
Well, that's what we hope, and that's kind of the expectation of people who are saying that that's now a market signal and people will move in. Obviously, people will be short term. There'll be some harm. I guess the other concern I have, and I have so much issues that I could talk about, but is that, and which I'm not going to, so Chairman, don't worry about it, is that there's a different world now, environmentally and generation-wise, than the Cleveland example. So bringing on and planning, you're only large megawatts going to be natural gas. You can't. How do you bring? You can't bring it on. The environmental regs are too stringent for us to bring on new Southern Illinois coal generation. And then the end thing is I'm really having this debate about re-regulated markets, just because I'm not sure with this environmental pressure that we can keep major baseload generation alive in a lot of parts of our country.
But just a brief comment is, if you look to the east from Illinois, you have a good example of what, if you go completely back to the old model, what the risk is there, because there you have a plant in Southern Illinois where the consumers are being paid stuff for billions of dollars over the multi-year life of the project. And I just read yesterday it's operating at a 10% capacity factor. Yet consumers are going to pay for that. Same thing happened in Miss Castor State in Florida. The nuclear plant closed down. They're now going to be stuck with the cost of the closure of the nuclear plant. So there's always that balance between who's going to bear what risk and how do you compensate them. And you're right, it's a conversation we're going to have to continue to have.
I understand in about 5 minutes or so, we're going to have a series of like 11 or 12 votes on the floor. So I'm going to recognize Mr. Plum for 5 minutes, and we're going to go as fast as we can.
I'll try to use less of that if I can. I just have one question for Braith Kelly. In nearly all the testimony today, I see a few common themes. First, that there are problems with the electricity markets. Clearly, there's a disagreement as to what the problems are and what the solution should be. Second, there's a disconnect between the state and federal roles in electricity, even taking into account the general concept that wholesale markets are regulated by FERC and retail by the states. There's a blurring of those lines that needs resolution, as states are still responsible for guaranteeing service to their residents and also for implementing a number of state and federal environmental policies that are affected by these wholesale markets. And I'm not here to take sides on how we resolve this, but clearly we're in a transitional phase, and I'm concerned that many of these unresolved issues can have a negative effect on consumers, public health, and the environment. For instance, I know the courts have ruled against New Jersey and Maryland in their efforts to ensure reliability through bilateral contracts, and that leaves us with a problem with regard to the responsibility of states. So, Mr. Kelly, I know your company is dealing with the result of this lack of clarity, so could you describe how the current situation affects project developers and states, particularly with regard to my home state?
It was one of the examples I used earlier. The cost of capital on that project is almost 30% higher. That all has to come from somewhere. It puts us in a position where we were under contract for that project. It was a much lower cost. We had what was called a CFD, a contract for differences. We bid in a competitive process with over a dozen other developers for a contract. That competitive process resulted in 3 projects being selected. Those 3 projects went forward and had to go through what was the MOPR screen to determine if they were economic. 2 projects passed through, 1 did not, proving that the system worked. That project was not economic. It was not allowed to participate. Unfortunately, there's a great deal of confusion as to where the state's right to, under the Federal Power Act, to manage their generation collides with FERC and its authority. The rules are very, very clear. The rules were created about these contracts. There was very little doubt in our mind that we would get through that process. Unfortunately, there was litigation, findings by 2 courts that these what were called subsidies were not constitutional. That's going to have far-reaching implications. There are subsidies being considered in Illinois and for the nuclear fleet there. There are subsidies being considered in Ohio to keep First Energy and AEP's fleet. These are all subsidies, but these are the states making the judgment whether or not there is that collision lands where those courts I mean, it's going to be very, very difficult for the states to implement the Clean Power Plan without this tool, without the ability to support generation.
Mr. Pull, if I could just provide the slight, to balance out the point of view, I think it's important to point out that this happened in New Jersey, as you know, and in Maryland, and the proof and the difference in the models is in the numbers from the results. The developers said they needed these contracts or the projects would not go forward. The process Mr. Kelly described occurred in your state. The prices that would have been locked in for 15 and 20 years were north of 50 to 75% higher than the market clearing price for that same generation. They said they would not go forward without this contract for differences, yet when the court struck it down, they went ahead and did it anyway. And Mr. Kelly refers to the lower cost of capital. Well, that's because there's a different risk-reward calculation. The reason why their capital costs would be lower, and I question whether they would pass that on or not, is because everybody in New Jersey, all of your ratepayers under that program, would have been stuck paying for those plants at those inflated costs for 20 years when it turned out not only was there other generation available at less cost, the very same plants that said they needed the subsidy in Maryland and New Jersey went ahead without it. And the last point is it was 8 federal judges, 2 district courts, and 6 courts of appeal unanimously found, importantly, in the narrow context of these programs, not all subsidies, not renewable portfolio standards, in the narrow context of these contracts for differences, 8 federal judges said it was unconstitutional and preempted by the Federal Power Act.
All right, thank you.
This time I recognize Jim. Where'd he go? Is he gone? Okay. I recognize Mr. Tonko from New York for 5 minutes.
Thank you, Mr. Chair. Mr. Kelly, you've pointed out several potential problems with the language in the discussion draft amending the Federal Power Act. You also noted the need to update and modernize our grid system. As you know, there are many changes occurring in the electricity sector. In your view, does FERC have adequate tools to manage that grid evolution and modernization?
They do. My opinion is they need to utilize those tools and undertake to move forward. I think they need to empower the states to move forward and make it clear what the states can and cannot do, and then stand by that rather than throughout the process that we dealt with, we were told FERC has spoken by virtue of its silence, which is approval of what was going on in New Jersey and Maryland, and then ultimately there was a complete reversal when we got to the courts in their opinion. We need clarity when you make investments that are above $1 billion in infrastructure that is critical to reliability, the constantly changing rules throughout. We started with our projects in that RFP with a state reliability exemption. That was taken away by FERC. The states had the authority to do it. It was turned into a MOPR, Minimum Offer Price Rule 1, then MOPR 2, to create more barriers for the state, from the states doing what they have traditionally been empowered to do.
So are there other changes beyond that that the Federal Power Act should consider that would better facilitate FERC's and the state's management of the changes in this sector?
I think what we're seeing here is some of the state's current authority being, transitioned or given to FERC. It's concerning, but if that's a decision, if that's the direction that we need to go, then that at least it's a decision. And I think FERC lacked the authority or the jurisdiction, let me say, that resulted in our cases.
I get the sense that Ms. Kelly wants to comment. We've hosted her in our district, so it's good to see you.
Thank you so much. I would just simply add to that we as public power utilities are also concerned about the ability to comply with the Clean Power Plan and to make the changes to our portfolios that we think we may be required to do in some states because of these federal market rules. We share some of the concerns of CPV, and we actually are involved in the Supreme Court case regarding New Jersey and Maryland. Thank you.
Mr. Cook, thank you. And Mr. Cook, would you have any comments in regard to the modernization or evolution of the grid and FERC?
Well, certainly the promotion of advanced technologies and the encouragement that you have in the draft discussion to direct FERC to consider and identify how advanced technologies may support the grid, I think is good direction to FERC. In addition, I think one of the things FERC needs to look at, particularly for companies like ours who would like to expand out of one ISO and into another. And we offer a standardized product for consumers that can be utilized in grids, and that the markets are similar in other ISOs. I mean, as we transition from PJM to New York or New England or the Mid-Continent ISO, their rules for the kinds of services we provide can be vastly different. And that means in some cases we can't participate in the market, or in some cases we have to redesign our technology in order to participate in those different markets. I know there's a lot of discussion about how utility grids are different, but in most cases, I think if you buy a toaster, it works anywhere within the U.S. The grid is surprisingly identical across our country.
You know, you talk about this technology, and obviously storage is part of the enhancement that would enable us to have a stronger outcome. So do you see, do you anticipate that other states or markets will follow suit with some of the policies that we have seen that have advanced technology and expansion of distributed generation?
Yes, absolutely. And I think and I hope that other jurisdictions will follow the kinds of things PJM has done to encourage customer-sited storage facilities to be able to participate in their markets and provide valuable grid services. I think storage has huge opportunities for growth, huge opportunities for cost declines, and when combined, and I think one of the key components is combined to find the different resources and values that storage can provide. So a customer that's utilizing their storage for backup power, so they have power when the grid goes down, shouldn't be prohibited from also utilizing that facility to provide valuable grid services when there's no technological or other prohibition on that. There shouldn't be regulatory barriers that prohibit that kind of participation.
Okay. Well, I thank you.
This time I recognize the gentlelady from Florida, Ms. Castor, for 5 minutes.
Thank you. I'm going to follow up on that because I think the innovative cost-saving development of storage capacity, as you said, has a very bright future. And I want America to be the leader in the world in the development of that technology. So I was concerned that you testified that changes to PURPA in the discussion draft would complicate the future economic growth of this technology and be a significant barrier to entry in a state or region without a well-functioning market, or at least some competition. And many states, including my home state of Florida, doesn't have a competitive regional wholesale market, and small power producers don't have access. So would you provide us with additional, is it as easy as striking this language? Does it need to be changed? Could you go over what your specific recommendation is here?
And thank you. And in my opinion, I don't think the language is needed. I think you could strike it in its entirety. I don't see a dysfunction in FERC Order 688, which separates and says if there's an open market, large generators are assumed to have access, non-discriminatory access to that market, and therefore don't need any of the PURPA protections.
And then if the language is included, do you agree that it would harm the economic vitality of this emerging technology?
Yes, absolutely, because it changes the presumption, which is on the other side to say big stuff has open access and can utilize its wherewithal in those markets. Small stuff does not. And what the language would do is say small stuff does. And I think it's a factual matter, and having dealt with development of solar projects for over a dozen years, many of which are in the 50 kilowatt to 200 kilowatt range, there are myriad barriers that we face. And you know, the simple contracting mechanism that's simple for utilities, not simple when you're dealing with a commercial customer that's not used to this kind of arcane language and offer that. So the PURPA protections for the smaller generation, I think, needs to continue, but it's not absolute. As FERC balanced in its order, it said it's a rebuttable presumption. So if indeed you do have a big system that's serving a small municipal system, perhaps they do have open access and can go directly into the market. And that could be presented to FERC as a rebuttable presumption. So I think that's the proper balance.
Thank you very much. Mr. Shel, I think you gave the committee some wise advice. You said don't pass a law that will be outdated in the next few years. The energy market is changing, and there are new requirements, and it appears that the old traditional electric utility model does not match the challenges of the modern world. And there's been so much resistance from some utilities, and they have a mission to provide the the best return for their shareholders, and that is largely based on kilowatt hour use. What can we do in this discussion draft to begin to provide greater incentives to electric utilities to invest in greater efficiency and renewables, with the understanding we've got to maintain the grid?
A lot of it's frankly outside of what a legal instrument like a statute could do, because what's happening in every state, until recently you had, and we still do have these different business models, and we've been clear as an organization, we've got almost, like I said, 95% of our member assets in the RTOs. So in regions like yours that don't have open markets, frankly, that's not where an independent power producer can or would go. But what's really changing it for all of us, because the common denominator of just about everybody, I think, on the panel, except for Mr. Cook, is we're all in the central station power plant business, as we have been since the advent of electricity for the most part. And what's happening now is the technology is there to empower consumers regardless of the laws of the state. So you have, as you know, in Florida and elsewhere, initiatives on all these different distributed resources, energy storage, energy management. And so it's really the technology that's driving it less than the legal side. The challenge, however, is unlike just about anything else I can think of, we don't deliver electricity to this room or our homes in separately packaged units. And as someone said earlier, it's all part of this interconnected machine, essentially. And the challenge now is, as these distributed resources and storage come about, the whole thing has to work together. And we've got this federal-state jurisdictional divide. And while we might disagree on how to resolve it, I think that's one of the things that's going to have to happen, because the federal government will continue to have a role through FERC. You all have a role, of course, the states do. But I can't imagine any one particular law. Really, technology, as often as the case, is ahead of the law. But to the extent you can encourage more competition, I think then we're going to get the innovation and put the risk of the innovation on those who are bringing it to market rather than on your consumers.
Thank you very much.
Mr. Weigel, you try to get attention.
10 seconds. Just to clarify from your earlier questions, Congresswoman, number one, the PURPA proposals that we have would specifically not apply to markets to states that lack competitive markets, would therefore not apply to Florida. Number two, I'm not aware of any energy storage QF. Clearly, that is, energy storage is the holy grail for renewable energy. We all know that, and certainly nothing in anything we would propose, is, especially as a company that's put billions into wind and solar, this is something we want to encourage. So the last thing we would want to do would be to discourage energy storage through any PURPA amendments, but it's kind of apples and oranges. As Mr. Cook himself said, energy storage is not really a generation asset, and we're really looking at generation assets. I just wanted to clarify those 2 points.
Well, thank you very much. I want to thank the panel of witnesses, and we'll need to get together again soon to continue our discussion. But we do look forward to working with all of you, and we're going to need your advice and counsel as we move forward trying to develop a piece of legislation. And with that, we'll keep the record open for 10 days. And thank you very much, and see you soon. And with that, we'll adjourn the hearing.
You got a home run. You did a great job. You really did a good job. I'm impressed. Thanks.
Sure.
Good exchange.
He will. He does a good job.